Hi, good day. I'm Eze Enuma, Deputy Editor-in-Chief, and this is the first session of the LSA Academy, and we're going to be treating the Firac method briefly. Some of you are already aware or familiar with the Firac method or have already used this method in the course of answering exams or tests. But for those that are confused or do not understand this method, I hope this helps you. So before we proceed, I want you to understand that Firac is an acronym and F stands for facts, I stands for issues, R stands for rules, A is for analysis or application, C is for the conclusion. Firac is a method for legal analysis. It is used as an outlining tool to sort out case law. It is mostly used in hypothetical questions in law school and bar exams. Every law student must attempt the use of Firac at some point. Firac is a formula that is used in the broad sphere of legal writing, used by judges in delivering judgments, lawyers in writing briefs, in giving legal opinions, and so on. FARC is very important because it is useful for not just tests or exams, it's also useful to lawyers. Problem questions are not just about answering questions, it is also about the process of learning the law. It helps in critical thinking of matters that concern the law. So I will briefly talk about every acronym in the Firac method. So first I'll start with facts. The facts of a case describe what happened or the cause of the dispute. In examinations or tests, the facts are already provided for in the problem question given. That means the facts are already given in the question before you. The facts are the cause of action, the reason for behavior, and the events surrounding an action. Facts provide circumstances of the occurrence, who or what was affected, how they were affected, and so on. The next is issues. The issues are the legal questions that must be answered. The issues are the questions that will be used to solve the legal ambiguity in a case or problem question. Identifying the issues would help break down a problem question or a case. It identifies the legal implications in the case. In the context of a legal issue, it is used to refer to a question that asks whether a specific law has been violated. It may begin with whether or not to analyze if there was a violation of law or not. Coming to rules, the rules are referred to as the general principle of law concerning the issues given. The rules include the precedents, judicial opinions that are binding on the court in making judgments based on the doctrine of stare decisis. And by that, I mean judicial precedents, which states that courts are obligated to use past decisions. So lower courts are, or the decisions of the higher courts are binding on that of the lower courts. There may be more than one rule, they may be as much as applies to the case or problem question, different rules given. The rules are derived from case precedents and also statutes. Rules will help to give a correct legal analysis of the issues derived from the facts. They are legal summary of all the rules that will be used in their coming to the analysis or application. Here, the rules are applied to the issues developed from the facts. In the analysis, the rules that are already provided in the former step are used, including the exceptions to those rules as well. So these rules are applied to the facts of the case based on the issues. We had already discussed that the issues are questions, the legal questions derived from those facts. So the rules that you have given concerning the case or the rules that are involved in the case will be applied to the issues and analyzed properly or applied properly in this section. Here, an argument or explanation why a particular rule applies or does not apply would be given. This is an important part of the FIRAC method as it requires critical thinking. The facts of the matter have to be argued from both sides while sticking to the rules. Conclusion. The conclusion is the final part of the FIRAC. It directly answers the question presented in the issues based on the application of the rules. It is the outcome derived from the analysis. No new issue is introduced in this section. This part provides an endpoint to the problem question. The analysis conducted in the previous section would provide the information needed to determine the conclusion. That is, whether the condition has been met, if the elements involved were satisfied, if the conduct occurred or not, and so on. In cases where one is asked to advise the parties, in problem questions where you are asked to advise the parties at the end. In this part or in this section of the Firac, this will provide an area to give the advice to both parties or the parties that you are asked to advise. The advice given to each party will be stated in a conclusion, and the conclusion is basically derived from everything that has been said in the application or analysis. We would give an example. So I will be giving two examples in the course of this session. The first example, and these examples will be problem questions. So the first example, Tabai was charged for the offense of perjury, having falsely stated during the hearing of the offense of stealing that he has one wife, whereas he has 13 wives. Advise the prosecution on whether the alleged false testimony is material to Tabai's trial for stealing and the likelihood of his being prosecuted for the offense of perjury. For those that are not aware, prosecution is mainly the party that is against, the party that is not in support. I just wanted to clear that up. So in this case, the issues are whether or not the alleged false testimony of Tabai is material to Tabai's trial, whether or not Tabai can successfully be prosecuted for the offense of perjury. You could add your issues as well. This is just a rough example so that everyone will understand the Firac method. So for the rules section in these facts, I gave some cases and also some sections as well. Section 113 of the Criminal Code providing for the definition of judicial proceedings, Section 117 for perjury, Section 118 for the punishment of perjury, and so on. I'll quickly explain the R versus Onward case. In this case, the accused denied ownership of the car but was in fact the owner. It was held that he was guilty of perjury since the prosecution suspected that he bought the car in question from the proceeds of theft. The ownership of the car was material to the proceedings. I gave one element of perjury in this case because I do not want to go into it. So in the case of perjury, it is important that the false testimony given is material to the fact. So this is what your rule will somewhat look like. You could provide more cases. It is necessary. Cases are necessary in problem questions. But in application or analysis, this is where you apply the rules that you have given to the issues at hand. So in this case, it will be at the court's discretion to decide whether Tabai's false testimony of having one wife, whereas he has 13 wives, would be material to the case at hand. That's the case of theft. So it will be based on the facts given, but based on the facts that were provided for, you have to explain why or how it could be an offense of perjury. That's what would be contained in your analysis, and your conclusion would be the final endpoint of what you have decided from that analysis, whether you believe that Tabai would be charged with the offense of perjury, and what is your advice to the prosecution, and the likelihood of Tabai being charged for the offense of perjury. The likelihood of him being charged for the offense of perjury will be at the discretion of the court, and how much of a material fact the false testimony he gave. So the conclusion in this case would be derived from the analysis that you have given, what you conclude from the analysis you have given, whether or not the prosecution might succeed in charging Tabai for the offense of perjury. For the second example I have given, Michael Kosi, Nasrat and Daphne were suspects in a heist of 38 billion naira. They were arrested and taken into custody. They were not informed of the grounds of their arrest. Michael and Kosi were tortured and declared criminals because they worshipped Ogun, while Nasrat and Daphne were locked up for 2 weeks without food or water. Their phones were searched and belongings seized. Kosi was eventually shot because he refused to speak without legal representation, outlining the breach of human rights, if any. So this is a human rights case, and I've been able to bring out as many issues as I can. You may have or you may find more issues as well. We're not focusing on human rights, so I just want you to understand what answering a problem question or solving a problem question will look like. So issue 1, whether or not Michael, Kosi, Nasrat and Daphne were to be informed of the grounds of the arrest, whether or not the torture of Michael and Kosi is in contradiction to their rights to dignity, whether or not Michael and Kosi can be declared criminals based on their worship of Ogun. Whether or not the lockup of Nasrat Daphne is against their right to personal liberty and dignity, whether or not their right to privacy was invaded, whether or not Kosi has the right to life, and whether or not Kosi has the right to remain silent in the absence of a legal practitioner. All this, the rules will all be contained in Chapter 3 of the Constitution. If you notice in the previous slide, I stated the sections just beside the issues. That was for those that have not treated human rights yet, because I do not want to confuse them. So in the rules section, all the sections that I have given here are contained in Chapter 4 of the Constitution of the Federal Republic of Nigeria. That's what I mean by CFRN. You could also give other laws that are implemented and used in Nigeria by virtue of their implementation into Nigeria, such as the African Charter, the UDHR, and so on. I also took the liberty to write some cases as well. You could add as much human rights cases as you could think of. I will briefly talk about the Ramson Kuti case, where the court observed that the human right is a right which stands above the ordinary laws of the land, which is antecedent to the political society itself. These rights include right to life, dignity, personal liberty, and so on. You could add as much cases as you could remember, as much sections that are applicable as well. So the analysis would constitute the application of the rules to the legal issues. I'll briefly explain what the analysis would probably look like. So concerning the first issue, Micah, Kosi, Nashot, and Daphne were to be informed of their grounds of arrest. This is found in section 35 sub 3 of the Constitution of the Federal Republic of Nigeria, where every person is to be informed on the grounds of their arrest in a language that they could understand. The torture of Micah and Kosi is in contradiction to their right to dignity. Micah and Kosi, being declared criminals because of their worship of Ogun, is in contradiction of their rights. Section 36(5) provides that every person is innocent until declared guilty, and section 38 as well gives the right to freedom of thought, conscience, and religion. The lockup of Nashrat and Daphne is against their right to personal liberty and dignity. Their rights to privacy was invaded. Kosi had a right to life, and Kosi had a right to remain silent as well in the absence of a legal practitioner. So you apply the cases, or rather, not just the cases, but the sections given, or the sections that you provide in answering your problem questions to the issues that you have given. You apply them, give instances, exceptions as provided in the laws. You also apply the cases. Sometimes some cases may be similar to the problem questions. You apply the cases, the general principles of law, what the court has decided as well, into the issues given, and that will all be contained in your analysis. For the conclusion, I have provided a brief conclusion here. So for the conclusion I gave, it is evident that the fundamental rights of Micah, Kosi, Nashot, and Daphne were breached. They were not informed of their grounds of arrest. The torture of Micah and Kosi is in violation of their right to dignity. Furthermore, they cannot be declared criminals, as every person is innocent until proven guilty. Their worship of Ogun does not make them criminals. A person arrested shall be brought before the court within a reasonable time as stipulated in the Constitution. The Constitution further provides that a person is entitled to compensation and public apology for unlawful arrest. The privacy of citizens are to be protected. The right to life, right to legal representation, and the right to fair hearing were also breached in this case. Human rights are privileges given to each individual by virtue of being human. These rights should be upheld at all times to ensure that they are not trampled on and individuals are not treated unfairly. I have a better conclusion than the one that I have given. You could state it here. So the conclusion is basically the end point, what you have reached at the end of the day, what you have concluded at the end of the day. Thank you very much for watching. I really hope this helped you. Please stay tuned, subscribe to the channel, like, drop a comment, tell us what you think.